So we will address the copyright aspects and piracy in the realm of social media. Let's start with the general terms and conditions that are traditionally uploaded by the main players in that sector, and you will see that they all put caveats and considered that only copyright compliant materials and of user-generated materials can be uploaded on the different platforms. And with various terms, Instagram, for example, says clearly that the best way to do it is to only upload material that you have created by yourself. But as I can check with some young people, even when you create the video from your holiday, you are tempted to use existing music. You are making pics from famous buildings that are still copyright protected. So even if you are the creator, there can be copyright issues. This makes, of course, the life of right holders and of intermediary service providers quite difficult. We will now address, next slide please, some statistics, just that you realize that these global companies are handling a huge number of requests for notice and takedowns. Google on his websites, and that's a quote with a little bit cynically, Google Transparency Report. They only published the amount of notice and takedown that they currently handle. So it's nearly 5 billions, but they do not publish the amount of content that was removed based on these requests. TikTok is a bit more transparent. In the first 6 months of this year, well, it's a smaller player, they had received more than 10,000 takedown notices. But what is quite important and reassuring for right holders is that nearly 90% of the content was removed. Next slide, please. The current legal framework is organized by the e-commerce directive, and it's basically for hosting service provider, which are the social media. They host user-generated content. It's notice and takedown procedures. So basically, the social media service provider are benefiting from a safe harbor, provided that they are not proactive in the selection of the user-generated content that is uploaded on their platform. So the primary liability remains in the hands of the users and not on the shoulders of the service provider. That's quite important. Not yet. Next slide, please. Thanks. What is important, and there is I guess, a case that you have addressed with other speakers earlier. There is a pending, very important case with the European Court of Justice, which is the Google YouTube case, where the Advocate General Saab Mansgaard has recently published his opinion. And in that opinion, he clarified something that wasn't clear, and that was, I think this is bringing legal certainty on one specific point, because as I said, intermediary will only keep their safe harbor provided they are not proactive. And so the risk was that if content service provider would start checking before uploading whether user-generated content would infringe copyright, that this could be considered as being a selection of what can be uploaded on the social media, and therefore they would then, as a result, lose their safe harbor. Because the idea of the current system is that the service provider should not be proactive, they should only remove materials post factum when a right holder is filing a request for notice and takedown. And here, the Advocate General considered that provided this selection is only confined to identifying illegal content, it will not be considered to be proactiveness in the sense of limiting the safe harbor for the content provider, which is at the hoster provider. So that's, I think, quite important for the platform, and not only for the platform, I think, but also for the community in general, because the risk would have been that if the service provider would have been considered to lose their safe harbor, if they would pre-select the possible infringing material, that would have as direct consequence a lot of work, additional work for the right holders in monitoring what has been uploaded. So it's a cost associated to that. And with respect to the end user, there would be a risk that since the service provider would lose their safe harbor, that they would then be much more proactive in selecting upload of user-generated material, and that would, there would be a risk of censorship at a global level, since when a service provider loses safe harbor, he would be liable for any kind of infringing material. And there is no case law for the time being, but one risk is that if you lose your safe harbor, you lose it not only for the material that you have selected, but you lose it globally, which means that they would be liable for criminal material that would be uploaded, pedopornographic videos, etc., etc. So it would be a very large mess in case this point would not have been clarified by the Advocate General. Let's hope that this would be confirmed by the Court of Justice. And in line with Article 14, there is, in addition to the notice and takedown proceedings, there is in parallel the Enforcement Directive, Article 11, that in the event that the service provider would not delist the infringing material, the right holder may seek for a short track proceedings in front of the courts having standing on these specific issues. Next slide, please. So that's a summary of the current system. If there is infringing copyright content, the right holder need to be proactive in the current legal scheme, sending a notice of takedown. It will be analyzed by the social media platform, and in case they are convinced that there is indeed an infringement, they will remove the infringing content, and if they do not do that properly, based on Article 11 of the Enforcement Directive, they could be sued to take action. Next slide, please. We have now a new directive which has been extensively lobbied and commented. It is the DSM directive, and there is in this DSM directive a new regime. For the time being, unless I am not well informed, no member state has yet transposed Article 17 that addressed this new liability regime, and probably because the Commission is working on guidelines with respect to the negotiation between the platforms and the collecting societies that are representing the right holders. As you know, the Commission just published recently a draft guideline on these negotiations, and this is under consultation. So we can assume that once this guideline will be finalized, that will be inspiration for the member state legislators in order to transpose properly Article 17. Basically, and I will be short on that since other speakers are addressing in depth Article 17. The service provider are supposed to negotiate framework licensing with right holders in order to avoid any more issues and notice and take down on infringing materials, since there will be license. But in the event that such license has not been executed between the service providers and the right holders, by default, the service provider will not benefit anymore from the safe harbor unless, and that's entails a reversal of the burden of proof, unless they bring the evidence that they did their best efforts to obtain these license, and also best efforts to ensure the unavailability of these infringing materials, which would, and this is discussions that we will address later in the Polish pending case in the European Court of Justice, is this entailing filtering or not, and they have to act expeditiously in order to delist, dereferentiate the infringing material. So this is a complete change of approach, and this raised indeed a lot of questions that is currently under discussion with the European Court of Justice in the context of what is called the Polish case. Next slide, please. And I suggest that we spend some time on this Polish case, because that could have a serious impact on the future of this new regime, since the Polish government introduced proceedings against the validity of Article 17 of the DSM directive. It's perhaps interesting to know that only member states can, an agency of the European Union can introduce such appeal against a directive. Private entities will only be able to challenge the validity of the DSM directive only when it will have been transposed by member states, because they need to be directly impacted by the EU-driven legislation, which is in principle not the case until the DSM directive is implemented and transposed by member states. So only Poland did that. It is commented that Poland did that only for electoral reasons, in order to secure the votes of young people making use of lots of infringing materials, but that they were not really considered, not concerned by the genuine human right aspects of that are at stake in this Article 17. But this is only political comments that I will not address further. What is interesting for us as lawyers is to see what is really at stake here. And I personally identify indeed some risk on the validity of Article 17 of the DSM directive. First of all, because it touches the e-commerce directive, which is the instrument that regulates the liability of intermediaries and the safe harbor. And if you look to Article 1, paragraph 2 of the DSM directive, it is clearly stated that the directive shall leave intact and shall in no way affect existing rules laid down in different directives, including in the e-commerce directive and in the copyright directive, the 2001/29, and in recital 16 of the InfoSoc directive 2001/29, it is clearly mentioned that the liability issues are addressed in directive 2000/31, the e-commerce one, and the last sentence of recital 16 mentioned this directive is without prejudice to provisions relating to liability in the e-commerce directive. So if you combine these three elements, Article 1, 2 of the DSM directive combined with recital 16 of the InfoSoc directive and the rules that are stated in the e-commerce directive, in fact, Article 17 is breaching these articles, which means that there is a fair risk that the European Court of Justice disqualify and annul Article 17. Moreover, there are questions that has to be raised with respect to the general principle of proportionality, because in order to protect private rights of the right holders, which are of course legitimate interests, it is outsourcing all the liability and the cost to protect those rights to a third party, which is the online service provider, and who is on top of that to some extent conflicted, because he has to conduct his business, and in parallel he needs to be the judge of whether something is copyright protected or not. As we know, copyright laws are not fully harmonized at EU level. There are two elements where there are significant differences between the member states, i.e. the threshold of protection. In some member states, like the Benelux countries, the threshold is extremely low. But in Spain, for example, the threshold is much higher. In some jurisdictions like France, the moral rights are without statutes of limitations. Moral rights cannot be assigned nor waived in France. In UK, for the time being, they were still in the EU, moral rights can be assigned, in the Netherlands as well, if I'm not wrong. And in Belgium, for example, moral rights, there are statutes of limitation, but they can be waived, but they cannot be waived globally. So this means that as an online service provider managing a social media will be obliged to have specialists in IP rights for all 28 member states because of these discrepancies, which is an extremely burdensome and costly exercise. So there is a risk that to limit this risk and to favor the business model and the profit of the service provider, that they will be tempted to make more censorship on the net. So these questions are really fundamental, I think, for the future of our democracy, and we are looking forward to read the decision of the European Court of Justice in this case. Next slides, please. Next slides. So, putting aside the reservation that I just expressed on the validity of Article 17, it is interesting to see that the motivation and the direction where the EU Union wants to go is to to play a key role in the construction of copyright online and securing that, taking into account the interest of the three sides of the triangle, I would say, the users, the right holders, and the players. In this respect, through the DSM directive, they convey the principle of co-regulation and partly outsourcing of states' liability. We will see that inspired probably by the GDPR in data protection, they will move from a co-regulation to a self-regulation, but I will explain that in one of the last slides of my presentation. We noticed that notwithstanding the fact that the DSM directive addressed the issue, they didn't create further exceptions, and they did not harmonize further the exceptions to copyright. As you know, we have in the Union a closed list of exceptions, but this closed list is like a menu in a restaurant where each member state can decide with some exceptions that are imposed whether they incorporate these exceptions or not in their legislation, which means that by the end of the day, you don't have a full harmonization of the exception. Moreover, some member states, and in particular France, and for the time being UK, create a freedom of a panorama exception. What is the panorama exception? It is typically when you are on holiday with friends and you take pictures of your friends, but in the background you have buildings and protected materials or cars or whatever. This would be covered by the panorama exception. I have doubts about the validity of these exceptions since we have, as I said, a closed list in the EU, which means that member states are not allowed to create new exceptions, which puts an additional hurdles for the service provider to manage properly piracy on their hosting device. Next slide, please. Here, what I would like to address with you is the fact that in recent cases that you have certainly discussed in previous presentations, the European Court of Justice had an opportunity to extend or to make a kind of compromise between the EU approach to exception to copyright and the Anglo-Saxon approach. As you know, in the US, they have the concept of fair use, which is defined by case law and with no comprehensive list of exception. In the EU, we took the opposite approach, no general principle, only a closed list of exception. And in various cases, one is a quite interesting case. It's called the Renkoff case. It was a student in Germany, I think in North Rhine-Westphalia. Yes, in North Rhine-Westphalia, it's on the case. Had for a presentation at his school, he uploaded from an online travel portal a picture from a city in Spain where he went for holiday, and he quoted the name of the photographer and the reference to the travel portal, but it was not through a link. He copied the pictures and uploaded in his presentation. Since it was a very good presentation, the school decided to upload it on the website of the school, and the portal the travel portal and the photographer considered that this was a breach of copyright because it was an unauthorized communication to the public. And we could see in this case that the Court of Justice was extremely strict in the interpretation of the communication to the public, since they considered that this was indeed a breach of the exclusive rights of the author. So there you could see that the court didn't seize the opportunity to combine this communication to the public with pedagogic aspects, absence of willingness to make profit, etc. They took a very strict approach on what is a communication to the public, and if it's not authorized and it doesn't fit within the exception existing exception, it is a breach. Next slide, please. In the Spiegel Online and in the Afghanistan paper that were addressed by the same Advocate General, here you had a German politician who wrote a book on sexual acts of adults with children. There was a fight with the publisher, and the publisher decided to publish, in order to defend his case, the version that he had published and the original manuscript to bring the evidence that he didn't distort the original manuscript of the author. And he was trying to defend that he could rely on news reporting exception and on the freedom of expressions. So he was trying to combine, to extend the scope of exception with human rights. And here the court said that human rights cannot be used to create new exceptions to copyright, which is, I think, a lost opportunity by the Court of Justice to put some fair use in our system, which would also enable some more flexibility and to adapt the case law to lots of situations that cannot be foreseen by the legislator. And next slide, please. And the same position was taken by the court in the Afghanistan papers. That was a German newspaper that reproduced some report from the German army in Afghanistan. There is a debate whether it was copyright protected, but assuming that this was copyright protected, the same position was taken by the court that it's not because it could have been interesting for the general public to be aware of these papers that copyright law should not be abide with. Next slide, please. So what are the next steps? And it's interesting. I have my presentation today because, as some of you might have read, the Commission published yesterday an action plan on intellectual property, which is quite interesting. There is also there has been a consultation, extensive consultation, until end of in September this year. I don't remember the exact date, but until September there has been a consultation on the new Digital Service Act. The Commission promised that they would revise the e-commerce directive by the end of this year. So there is a lot of activity. But what is interesting to read in this action plan that I read yesterday night in preparation of this presentation is that the Commission is willing to change the system that is set up in Article 14 of the e-commerce directive, where it is forbidden to be proactive at the level of the service provider. So it goes a bit in the direction of what I explained, that the Advocate General, the Danish Advocate General, mentioned in the YouTube case, or they will favor voluntary action by service provider in order to combat piracy on their platform. The power of OLAF and enforcement authorities will be increased, and the question is whether we might move from co-regulation to a self-regulation. And I see in these two last points the increasement of the enforcement authorities, the power of the enforcement authorities, and moving from a co-regulation to a self-regulation, that there is a big inspiration from the GDPR. As you know, in the GDPR, there is this new concept of privacy by design, which puts, in fact, a huge burden on the stakeholder, where they have to structure their business model in such a way that is compliant with the GDPR. So we could, that there is a possibility that the Commission would then think, I'm thinking loud here, a concept like IP by design, where platforms would be obliged to make sure that their platforms will be structured in such a way that no infringing material can be posted. And with respect to the improvement, the increase of the enforcement, the power of enforcement authorities, again, as you know, in the GDPR, the data protection authorities can impose fines up to 4% of the global turnover of the players. So perhaps this is also a direction where the Commission wants to go in order to make sure that the IP rights are better protected within the Union. It is also important, and they want also to create a toolbox, which would be a huge database, joint database accessible by all stakeholders, including the authorities, in order to favor, again, the combat against infringing and materials and piracy. So that's a quite ambitious program. But in one of the first declaration of the new Commission, with the success of the GDPR that was inspiring all other countries in the world, the Commission indeed wants to play this forefront role, where they come with, where they address before the other big blocs, China and US, key issues in order to pave the way for EU legislation being, in fact, global legislation. And so we see this tendency more and more in the strategy of the European Union. I think that, next slide, but I think it's, yeah. So next slide, please. So, and that's how it can be done, but we addressed it already in the beginning. That member states shall provide in Article 17 online, shall provide authorization. They shall organize, how to make sure that service provider, online content sharing service provider, obtains an authorization in order to avoid that there would be any more infringing materials. But we should mention that although there is an obligation to negotiate and to do this best effort to negotiate to get this license, there are some caveats in this respect. It will not be a legal license. There is no mandatory collective management, although the member states can organize that in their own system, which means that if there will be no mandatory collective management, the task will be extremely burdensome for the online content sharing service providers. And as you know, this license will only cover user-generated content that is not posted with a on a commercial basis, or where these activities are not generating significant revenues for the user. Since we know that there are lots of bloggers and influencers that are making money out of privately posted material, this will again create a lack of legal certainty. So that's also an additional issue that will have to be clarified by the European Court of Justice. Next slide, please. Voilà. I would like to thank you, and I'm open to take questions if this is something where, if we have still time,